Happy Friday. Nice to see you. Fran McGovern here, Mike Plulek with us as well, Eileen Gambino. So today we're going to be talking about property modifications. Everything looks great. Now let's change it, right? I moved into this community and it looks wonderful. I want to change everything, right? So that it sometimes baffles the lawyers, the managers, etc. So, but as you know, we always have these preliminary announcements. And today we have the usual ones. This is not legal advice, right? This is just educational purposes only. It's cannot form an attorney-client privilege with respect to today's seminar. The information exchange will not be held in confidence. The information exchange does not constitute legal advice. And if you want to have an attorney-client relationship, you got to go out there and hire a lawyer. So sign a fee agreement and either, we prefer the lawyers be us, but if not us, then you have to go out and hire another lawyer to give you legal advice. So today is not legal advice. And nothing today discussed will be kept confidential. So if you type something in the chat that says, hey, I want you to tell me about my violation of the porch roof that I installed in my community, and I want you to get me off of the violation on that, that will be out there to the whole world, and you will be acknowledging your violation. And we can't help you with that, right, if you've admitted it online. So the next thing is we'll do dog of the day. There we go. We got the dogs of the day. Nice dogs. We got a 3 for today, and these are all owned by the same person, Ed Lafian from AR Management. Thanks, Ed, for sending them over. So we have let's see, we have Abraham, who is the boxer mix up there, I think, sitting on the hot tub, and then we have Yuki, who Ed says is mostly Great Pyrenees. These are big dogs, and I don't even know how to say this. Theodone, who is Yuki's father. When I saw Abraham and 3 dogs, I thought I was going to get a Dion DiMucci song, Abraham, Martin, and John, but I did not. I just got Abraham. So for those of you who have not heard that song, you can check it out on YouTube, Abraham, Martin, and John. But thanks, Ed, for the dogs. Very nice dogs, very pretty dogs, very, very furry dogs. God bless whoever does the vacuuming in your place, because there are some furry dogs there. So anyway, we're also going to have a preliminary thing because Mike and I are getting so much contact on the Corporate Transparency Act, right? So the Corporate Transparency Act, for those of you who have not participated in the Corporate Transparency Act seminar that I did probably several months ago. So this is the McGovern website. You kind of click in here, First Friday with Fran, right? And then just go to, did you miss a First Friday with Fran? And you just click on this. Yes, that brings you to our YouTube channel with all of these kind of back and forth First Fridays with Fran that look a little jerky on YouTube for some reason. I don't know why. We are not we are not the most technical law firm in the world, but at least we made it to YouTube. So if you go down to the videos and just click over to the side here, the one on the Corporate Transparency Act is this one right here. The one titled "A Copy of My Driver's License." Really, right? Because you need a copy of your driver's license. So anyone who wants to kind of bone up on the Corporate Transparency Act, the seminar that I did on the Corporate Transparency Act actually has a share screen of going through the website on the Corporate Transparency Act and how to actually register. I'll stop share for a second. The Corporate Transparency Act requirements are still in place. There are lots of rumors out there. We don't have to do it. It doesn't matter. Blow it off. No, the requirements are still in place, and you must do it on or before January 1st. So most associations are slow walking this process, right? They're slow walking the process in the hopes that one of these lawsuits that have been filed by CAI not CAI New Jersey, CAI National, or one of the other lawsuits that are out there will be successful and stop the enforcement of the Corporate Transparency Act. In the meantime, though, you don't want to risk violation. So like I said, most associations are slow walking it. Just keep in mind, once we get into November, December, you're going to have to think about actually complying, because if you don't comply, the enforcement fines are very stringent, right? So you don't want to get down that road. So just keep talking to your management company about that. Keep talking to your law firms about that. Keep talking to us about that if we are your law firm. And be careful you don't get jammed up as of January 1st. You don't want to be sitting there on New Year's Eve, trying to scramble and scan in somebody's driver's license and have a problem. Let's see. Okay, so we'll go into today's property modification issue. So we'll start with the developer's perspective. What is the developer's perspective? So the developer's perspective is, I am here to sell homes. I'm here to sell homes. I'm here to sell units. And then the community is yours, not mine. I'm the developer. I walk away. You can live happily ever after if you want and change nothing, or you can change everything if you want, right? So the developer's perspective is keep it uniform during the sellout. Keep it uniform during the sellout, right? Because that's what was approved by the town. That's what was on the plans. That was what was in the public offering statement. They do not want to make changes during the sellout process, right? They have put a product out there, a housing product out there, and they want to have it stay the same during the sellout process. So some homeowners buy into a community and they say, hey, Fran, this is just too plain vanilla for me. Well, the developer is going to push back on you if you try to make significant changes during the sellout period. And that makes sense. The other reason for that, the developer reluctant to have any changes made, is the developer has certain warranties, right, in terms of selling out a new community. And the developer doesn't want to allow modifications to things like porches, decks, roofs, etc., that will jam up his or her warranty requirements. So they want to keep things as planned during the build-out period. There's one caveat to that always comes up and always creates issues for the manager. And managers wind up tearing their hair out, if they have hair, tearing their hair out over this nightmare. Because what you get is you have someone making modifications during the developer build-out, sellout period. And the manager goes, wait a second, the board never authorized that modification. And the person responds by saying, well, the developer said it was cool with him. The developer saying it's cool with him is not enough, right? So you may have a situation where the developer, for example, to try and close a deal said, sure, you can put on a paved patio all over the place, make the whole backyard impervious just to close a deal. But that doesn't mean it's compliant with township code or the association's rules and regulations. So you just have to be aware of that. The developer said I could do it generally holds little, if any, weight. Okay, rationale for property restrictions. So generally, associations, by definition, are planned unit developments. It's planned. And generally, they are built at a higher density than what you would see in a community that has 1 acre lots or things like that. So in general, the rationale for property restrictions include things like preventing blight, making sure that property and curb appeal is preserved, right? Because when you have high density housing and people are living on top of each other, whether it's a townhome community, a single family homeowners community, or a condo, once you get one missing tooth, one bad tooth, everyone knows when they lived in communities that were not association, any kid could remember the house on the street that was the scary house, right? You don't want the scary house in your association. And part of the reason for association property restrictions in terms of modification is they are maintained and they're not modified in such a way that people want to move away from them and run away from them. So it also enhances curb appeal. It protects things like value of the property, right? It protects things like drainage plans and drainage functionality, right? So where do you see that most? In active adult communities where they're single family homes and they have swales between every home. And the first thing someone wants to do is plant 20 rose bushes down the middle of the swale. No, the swale is there for a reason, right? The water runs through that swale and hopefully runs through that swale and drains into further drainage structures like yard inlets or street inlets, right? So when people go out there and start modifying the grading and drainage, that's a problem. So you're impacting functionality. What about security? So if people go out there and start planting inappropriate trees, planting shrubbery and not taking care of it, that can impact your security. There are a number of cases across the United States involving homeowners associations where plantings, for example, shrubbery, et cetera, were not maintained or they were installed in inappropriate places. And attackers use those overgrown areas to hide from people outside of parking lots and then attack the people in the parking lot. So there are many, many reasons for property restrictions on modifications, both from a functional standpoint, a curb appeal standpoint, a property valuation standpoint. So there's many good reasons for it. Authority for property restrictions and restrictions on modifications. So in condos, master deed, right? Master deed. In homeowners association, the declaration. You also have rules and regulations. You also have resolutions of the board, right? And municipal code and laws, statutes still apply. They do still apply within your community. Where do you see people really lose the handle on application of state law and state regulation? You see it a lot of times in buffer areas. So environmental buffer areas. So behind, for example, homeowners association, they may say there's an area that cannot be cut. Cannot be cut. The trees can't be cut down. The shrubbery can't be cut down, whether it's because it's behind a natural area preserved by the town or a waterway. So waterways, streams, et cetera, that are behind your property generally have a transition area or a buffer area that cannot be cut. And you'll see people, and this happens with some regularity in our firm, a homeowner will be like, yeah, my lot line goes out another 20 feet. Therefore, that means I can cut anywhere I want. I want to cut everything out of there, or I want to spray, chemicals on it that kills everything. No. So just because you're an association and just because you even own the property, if it's restricted with environmental restrictions at the state level, the federal level, or the regulatory level, doesn't mean you can do whatever you want, even if the association's governing documents don't speak to that issue, right? So if there are buffers, wetland buffers, natural area buffers, et cetera, they have to be respected. So you have to be very careful in terms of cutting trees, shrubbery, undergrowth, et cetera, in areas like that. That's where a lot of people get blindsided because it's not always apparent, right? And it does feel right. It feels right if you're like, yeah, I own that property, therefore I should be able to cut whatever I want. So be careful. So that's the authority for property restrictions. What about requests to modify the property exterior? Outside of the building, right? The initial question is it common element? Is it common property? Is it homeowner property, right? Because a lot of times that's the beginning part, and we'll talk about more later. Right, so you want to ask the initial question, is it common element? Because generally common element is much, much more difficult to get the ability to modify than homeowner element, right? So if the homeowner owns the roof, it's generally pretty easy to get permission to modify, and in some cases the board is required to give permission to modify in situations like solar panels, et cetera. But what if that area is common element? If it's common element owned by the association may be permitted, and often is permitted, to restrict any and all modifications, right? So you got to keep in mind what's common element, what's unit owner owned or homeowner owned, and even if it is homeowner owned, there are some documents written, especially in townhome communities, where it says the homeowner owns the roof. However, the association is obligated to maintain, repair, and replace it. If the association is obligated to maintain, repair, and replace it, the association has much greater power to regulate that roof or that piece of structure, even though it's owned by the homeowner.
Hey, Frank, can I
Yeah,
just
go ahead.
make a quick distinction here? This is like a fundamental difference between a condo and a townhome or homeowner association. So with condominium associations, there's a master deed where the association owns everything in the entire parcel of land where the community is located, except for the fact that in the master deed, it says condos are carved out from basically sheetrock in and some other things that are exclusive to that unit, like an HVAC line, maybe some water lines. Everything else is owned by the association versus a townhome where the owners own from the four corners of the lot and everything located on their lot. Same thing with a single family home homeowner association. And it's just an important distinction because sometimes it's really unclear where governing documents don't really specify. It just gets kind of, everything looks a little gray. So The distinction is if it has a master deed, it's a condo. If it has a declaration of restrictive covenants, that means it's a townhome association where people own from the four corners of the lots, or a homeowner association, which is the same.
Yeah. Yep. Thanks, Mike. That's a really important distinction. And it's especially confusing in the townhome context, right? Because some townhome style architecturally are actually condos, right? They're actually condos, even though architecturally they're townhome style. But then there are also townhomes that are basically fee simple townhomes. As Mike said, they own their own lot, they own the entire building, they own everything. So once you get into townhome configuration, it can be a little funky. So what about standardized modification within management scope of authority? What do I mean by that? So in many associations, there are no ground rules to begin with, right? So the developer's out, the developer walks away, and the association, the board, I think if they're proactive, can take a whole load off their shoulders if they decide these particular items that are subject to modification are approved if they fall within this framework. And what am I talking about? The number one thing when the developer goes away is what? Storm doors, right? We all want to put in storm doors, full view glass storm doors or half the storm doors, whatever. So what I would suggest if a developer hasn't done that from the beginning, have the association select what type of uniform storm doors the association will allow, have a resolution as to storm doors, adopt a resolution and saying this type of modification, for example, can be approved by management, doesn't have to be by the board, as long as it falls within the framework, right? If it's a different brand, no, it doesn't fall within the framework. A different color, no, it doesn't fall within the framework, right? Different size, buckboard, half door, all that other stuff, no. If it doesn't fall within the color, this size, this view, etc., it doesn't get approved, right? And this goes with respect to some other things too. So we see it a lot in storm doors. We can see it with respect to flagpole installation. If you allow flagpoles, you could say, okay, we allow these types of flagpoles. And management can approve anything that falls within this scope, right? You have to come up with specification. Some other things, planting beds. Many associations have standardized planting bed resolutions so that management can just approve it as long as the modification application falls within the specifications the board approved. What about cameras, security cameras? Does everyone have to be custom? No, the association can put together a resolution that says you're allowed to have security cameras, you're allowed to have Ring doorbells, etc. Not that I'm endorsing any kind of brand, but only if they are installed here, only if they don't damage the common property, only if the range of the camera does not, for example, shoot directly at their neighbor's kitchen window. You see what I'm saying? You can specify the range of the camera only if there's no sound recording, for example, going on. Things like that. What else? Patios. Some associations, we have some associations in Montgomery, for example, that have patio extension standardized approved resolutions. So that if you want to extend your patio, the board has already worked with its engineering company to say, if you want to extend your patio, here's the spec. If you're proposing to do that spec, it's approved automatically by management. Once management gets the application, you can do that. If you want to extend your patio some other different way, no, that has to go to the board, right? Patio extensions, where else? Skylights. Skylights, you could do a uniform skylight specification. Backup generators, right? If you want to do a backup generator resolution. So these are just ones that the association could consider. Where else do we see it? Privacy fences. So privacy fences, you can do a standard privacy fence. It has to be made of this material, this color, blah, 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 blah. Feel free to install it. If management approves it, it doesn't have to go in front of the board. What about electric vehicle charging things, right? If you fall within the specification, go for it. Management can approve it. Doesn't have to go in front of the board. Okay, then we get on to non-standard modification requests. Non-standard modification request, obviously anything can be a non-standard modification request if the association's board hasn't approved standardized modifications. But where do we see them the most? Additions, right? Additions, where we want to put on a sunroom. Okay, generally that's a special thing, right? And again, as we were talking about before, whether or not it impacts the common elements is really important. Grading and drainage is really important. What about if the modification impacts the irrigation system, right? That's an important thing, right? Because we have people who just put pavers in the back, and they actually pave right over sprinkler heads, right? That sounds crazy, but it happens with some regularity, right? They don't even think about when they're putting in the paver extension that they're paving right over the sprinkler heads and or chopping, God forbid, the sprinkler lines themselves, right? Both the electrical wiring and the lines themselves. So those types of things should go in front of the board. The board should vote on them, and the board should have a modification agreement with a specification attached. The board approves the following thing attached as Exhibit A. If you don't have Exhibit A, you have nothing to approve, right? So there are associations that say, yeah, you can do a patio extension. And then 6 months later, we as the attorneys get a letter that say, they built a crazy patio extension. I go, okay, well, show me the specification. And they go, no, we just said, we gave them approval to do a patio extension. We thought it would only be a 6-foot patio extension. I'm like, what made you believe that, right? So if you're going to approve it, you have to have a modification agreement with an attached specification, which is usually Exhibit A. What about, but the township said I could do it? So it's wonderful if the township said you could do it. It's wonderful, right? Most townships for modifications of any significance do require township approval, right? If it's a significant modification, especially involving plumbing, gas lines, things like that. But the fact that the township said you could do it or gave you a permit, right? We always get but I have a permit from the town. Well, that's nice you have a permit from the town. We're happy about that. But the board has no idea what you're doing. Why are you ripping your house apart? Right? Why are you converting your garage into a screen room? Right? We've seen that. I don't know how many of you have that in your community, but in South Jersey, down by the shore, there are lots of people who have converted their garages into screen rooms. They have those like screens that come down instead of the garage door. And people, the board goes, what the heck's happening here? So just because the township approves it does not mean that the association has approved it or that the association must approve it. If the township says, cool, you have a permit, the association can still say, not so fast. This doesn't meet our rules and regulations. This doesn't meet our requirements. Therefore, you're rejected. And we have cases that generally threaten the association with lawsuits over that, where people regularly make the argument that if the township approves it, the association must approve it. Not so, right? So don't believe it. Don't believe the hype. It's great if the township and the association work hand in hand. Monroe Township historically, right, who has a lot of adult communities, has traditionally worked very well with the Monroe Township associations in coordinating modification approvals with the association's modification approvals. So oftentimes in Monroe Township, if somebody comes in for an application for a permit, the first thing they'll say, is your home in the association? Yes, it is. Okay, do you have the association's written approval? No, I don't. Okay, we don't even want to hear from you, right? So some townships are very proactive on that, but many are not, right? So you have to be a little careful with that. Functional concerns. We talk about functional concerns. What we talked about before, grading and drainage is a very big functional concern. That goes to plantings, that goes to paving, right? Impervious surfaces, extensions of patios, things like that. Where else is it a big thing? Penetrations of roof or siding. Penetrations of roof or siding, because penetration of roof and siding always sounds like what? Water infiltration and mold. Water infiltration and mold, right? Because they're cutting holes in the roof and the siding. And if they don't do it right, if they don't do it with the right specification, engineer, and contractor, you're going to have a major problem. And as Mike described before, that's a major problem in condos and townhomes, right? Not as much a big problem in a single family home, right? Because if you cut a hole in your house, in your roof, and you own the roof, the association doesn't care as much. But if you cut holes in your roof and your siding, it's a condo or a townhome style condo, especially if the association owns the property, there's water infiltration. The association is going to have to deal with that. And more importantly, if you don't have a modification agreement that is recorded, okay, and the house is sold, and then after the house is sold, that skylight leaks, who's going to come back to the association and say, replace the skylight? The new owner. Because they're going to say, I don't know anything about this. This was part of the roof. I bought this unit. It had a skylight. I don't know what you're talking about. Why are you saying it's my skylight? right? It turns into a huge argument. If you have a modification agreement recorded that notes the skylight, emphasizes the fact that the homeowner is responsible for maintenance and repair and replacement of the skylight, it's not an issue because the new purchaser will have that in their title search when they go to closing. You know, I don't know if these things are still popular, but for a long time we were seeing solar tubes too. You ever see solar tubes? They're like skylights, but they're like a tube that comes through the attic and shines sunlight into the room. But same thing, it cuts a hole in the roof. So that's functional concerns. What about aesthetic concerns, right? Aesthetic concerns involve things like curb appeal, right? What about the color? What about the color of the home? What about the style of the home? What about the architectural elevations, right? So many governing documents provide that the same style unit cannot be next door to each other, right? So you'll see a Hovnanian or a Toll House or whatever, they have a nut edge unit and a walnut unit and a Beaverbrook unit, blah, blah, blah model of home. They can't be next door to each other. So an association, say someone says, well, I want to put dormers on my roof, right? And I live next door to a nuts edge unit that has 2 dormers on the roof. And if you put 2 dormers on your roof, your unit will look exactly like a nuts edge unit. The board would have to think twice about that, right? Because generally, when, especially in active adult communities, they want the homes to look similar, but not the same next door, right? It's like a variation on a theme. I don't know if that makes sense to you, but it's generally a variation on a theme. So you have to be careful with architectural elevations when people want to do things like put dormers on, convert garages, things like that. What about reasonable accommodation for disability requests? I'm not going to get into that today because for those of you who have heard me talk about this before, that is an entirely different seminar, right? When we get into reasonable accommodations for disabilities, the association must allow reasonable accommodations for disability, but it's case by case, right? Each one has to be a discussion of what is reasonable, what is proposed to be reasonable, what is proposed to accommodate the disability, etc. So we can have a separate seminar on that, but reasonable accommodations for disability must be permitted, right? Reasonable. Reasonable is the key there. And again, we can have a whole separate seminar on that. But if somebody comes to the association and says, hey, I have a disability, I need the following, I need to be able to do the following thing, can I do it? What you cannot do is say, no, that's not permitted here. You can never just say, no, that's not permitted. It may not be permitted, it may not be reasonable, but you must, at a minimum, engage with the disabled person in a conversation about how do we get to reasonable? What is reasonable? How is the modification helping mitigate the disability, right? So too many times, associations, when there's an application for a reasonable accommodation to make a modification to mitigate a disability, the board says no, right? And the lawyers don't hear about that until 6 months later when the association's getting sued because the association just said, no, go pound sand. We don't allow that here, right? And keep in mind, disability suits are what? Fee shifting statutes. Fee shifting statutes. So if the homeowner who requested the modification, reasonable modification, was improperly rejected, not only do you have to, you lose the case, right? You're paying your own lawyer. You're paying the applicant's lawyer too, right? So they sue you. There's fee shifting. You wind up paying the homeowner's attorney fees if she wins, or he wins. Be very, 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 very careful with reasonable accommodation requests in the disability field. What about interior modifications? This is a very big deal. I don't see anybody from our Gold Coast clients, but this is a very big deal in the Gold Coast, in the Jersey Shore, mid-rise, high-rise. Anytime you get over 1 floor, basically, in multiple home housing. Why? Because these modifications, even though they're interior, may seriously impact building systems, right? So if you're an active adult community, single family homes, generally doesn't matter if you change the plumbing to your dishwasher. Not so much, right? What's the big deal? your dishwasher may overflow and you get water on your floor. If you change the plumbing to your dishwasher in a 15-story building and the line pops and you're away for a 3-day weekend, that water is flowing and flowing and flowing down the entire column of units, right? That's a multi-$100,000 loss for the association, right? So people often discount applications for modifications to the interior of the unit because the unit owners tend to say, this is my unit. The document says I'm responsible for interior maintenance, repair, and replacement. Therefore, I can do whatever I want within the interior of the unit. Not true. The associations and mid-rise, high-rise in particular, and in certain cases, other styles of building, have to take particular care with respect to modifications within the unit itself. It relates to things like building systems. What else? Quiet enjoyment. Quiet enjoyment. Where does quiet enjoyment come into play? Well, think about it. An association has a policy that 80% of the floors must have padding and carpeting over the flooring. And nobody tells the association, but they install a parquet floor over the weekend. You are immediately going to get a phone call from the guy downstairs to the management office saying, I hear the lady upstairs tap dancing every night and their kids are evil and I hear everything, right? Tell them to leave me alone or I will sue them, right? Well, sound transmission, when you do modification inside a unit, is a huge issue, right? And that doesn't just go for mid-rise and high-rise. That goes for any stacked unit, right? Any stacked unit. When you see just regular stacked units that are 2 stories, we have lots of cases over noise transmission, right? Where the units were originally built with padding and carpeting, but then someone installed tile floors or someone installed hardwood floors, and everyone goes wild because the guy downstairs can't sleep, right? And the guy upstairs happens to be on shift work because, and I'm just using an example, he's on shift work and he comes in at 2 o'clock in the morning every night and walks across the guy below him bedroom. And the guy below him is waking up every night on the shift work scale, right? So modification of floor covering, very important in terms of quiet enjoyment. Same thing with risk of damage, right? Risk of damage to anything during the project itself in terms of a unit. Again, this is especially important in high rises. Electrical system, plumbing system, HVAC system, any type of major system in an association. In addition, people forget, even in 2 stacked condo units, that the structural elements in the unit are what? Are common element, as Mike described. Even though the unit itself, interior, is owned by the unit owner, things like major supporting beams are common. Too often, unit owners will say, you know what, we're remodeling our kitchen. And just like we see on TV all the time, we would love to take that wall down and make it open concept. Wouldn't we all love open concept? Yes, we would all love open concept. It's very trendy today, open concept, right? But what they don't realize is they are cutting supporting beams within that wall between the kitchen and the dining room. And we've had a number of litigations over people going in there and cutting down supporting beams. And the association's engineer, after they inspect, they say, Fran, no. They can't do it. You can't cut this beam, has to be replaced. It's got to be shored. The wall's got to be restored, or you have to put some type of engineered beam in, etc. To support the load, because structural members transmit the load of the entire building to the footings into the ground of the building, right? If those structural members are removed, you impact the structural stability of the building itself, cause a serious dangerous condition. So what else does that involve? Costs. If somebody's doing a major modification, the association has to figure out who's going to foot the costs. And that generally means legal costs, engineering costs. What is the cost to deal with a review of the proposed modification? So say, for example, I'm a legitimate person. I say, listen, I want to make my unit open concept. I want to tear out this wall and I want to connect the kitchen to the dining room. And I'm a legitimate guy. I want to do that. How do I do it? You would want a specification, a proposal, and then you would want an engineer to certify that that was an appropriate modification. And who should pay for that? not the association paying for its engineer, the applicant, right? Just kind of like when you go in front of the planning board or zoning board, you have to pay for your own engineering fees. You have to pay even for the township's engineering fees if they're going to review it. So the association has to make a decision how they're going to deal with charges for its experts and what experts they will require for the scope of the project. You see what I'm saying? Because if you're doing something that's really going to impact an electrical system, a plumbing system, a structural system, you want to know not what a homeowner says, not what the contractor says. You want to know what a licensed professional says, what's an engineer, somebody who was, involved in HVAC work, et cetera, that can sign off on this. Again, not just the contractor. You want an engineer. Okay, modification agreements themselves. Number one, you need the specification. You need the specification. It has to be in writing. We like drawings, right? We love drawings. So we like the written specification. We like the drawings. You must record it. You must record the modification agreement. Again, the reason you record a modification agreement is so that everyone thereafter knows that the modification is the responsibility of the homeowner, not the association. We're involved in a case right now where an association years and years ago allowed homeowners to put on sunrooms, right? They allowed them to put on sunrooms. They never had modification agreements. The association's in the process right now of re-roofing the entire community. And people who have bought subsequently are like, what do you mean we have to pay for re-roofing the sunroof? That sunroof's part of the roof. What are you talking about, Fran McGovern? We go, no. That was added later, right, by your prior homeowner, prior owner and title, and you got to pay for that portion of your sunroom roof. The association's not going to pay for that, and now it's a fight, right? It's going to be a fight because the new owner is going to buy in and say, hey, wait a second, I looked at the governing documents, and the governing documents say that the roof, quote, is part of the common elements, and the association is obligated to maintain, repair, and replace the roof. Right? And then you're in a debate. If you have a modification agreement that says the association acknowledges that this sunroom is going to remain the responsibility of the homeowner or the unit owner in this case, you won't have that problem because it's recorded. Even if the unit turns over 2 or 3 times, it's always in the chain of title with the title search that says sunroom's on you, pal, right? You got to deal with it. So that's important, must record it. You must think about the engineering costs, as I said, the attorney review. What about there are some associations that modifications require a governing document amendment? Sometimes that happens. Why would you need a governing document amendment? So in some of our Gold Coast type properties, for example, we'll get a phone call, hey, Fran, we're in Jersey City here, and we have purchased units next door to each other. We want to combine 2 units into 1 unit. Mm-hmm. How do we go about doing that, right? You are going to need probably a master deed amendment to deal with that if they want to combine a unit into 1 unit legally, right? There are people who do it not legally, but you may need a governing document amendment in certain cases. What else would you want in your modification agreement? You want to indemnify, defend, and hold harmless the association with respect to the modification. Why? If someone gets hurt or the modification itself hurt somebody. Somebody changes the swale and the swale floods out the next door neighbor, right? You want that to impact them, the people who made the modification, not the association. If somebody falls on a modification to pavers or extensions to decks or things like that, you want to make sure it's on the homeowner who made it, not the association. What else do you have to think about? Just the last thing, I know I'm pretty far in now, 4:45. I'll wrap up shortly so you can get back to your Friday afternoon. What about enforcement and the term estoppel? Generally speaking, the association's governing documents say if the association fails to enforce something, the association will not be bound by that inaction, right? So that sounds all well and good. It's not generally true, though, especially with respect to an expensive modification. So, for example, if you have governing documents that say no homeowner may make any modification to the exterior of the home without written permission of the association's board and or management, right? So that sets the restriction. So the association says, oh, that's nice, that's good. And one day, one of the board members is walking down, Walnut Street in the community and sees that the house 2 doors down from him has 4 contractors' trucks out front, and they already have a foundation in for what looks to be a 2-room addition to the house. Right? And the board president keeps walking and walks by and goes, that's weird. I don't remember ever approving that. And he goes to management, and management goes, yeah, no, we don't know anything about that over on Walnut Street. We don't know what's going on. And they go, okay, well, we'll see what happens. If it goes any further, maybe we'll do something about it. And then a week later, he walks by or she walks by, and the stick framing now is above the foundation. And it's, gosh, this really does look like they're building a room, right? And it goes back to the manager, goes, that's weird. There's actually framing going up. Did you talk to them yet, Bob? And Bob goes, no, I don't know anything about it. Well, maybe you want to reach out and make a phone call. And Bob reaches out and makes a phone call to the homeowner and goes, hey, man, what are you doing? Oh, I'm building, 2 more bedrooms onto my house because I don't have enough room, blah, blah, blah. And the manager says, hey, well, this is going to sound kind of weird, but our documents say that you have no right to make any modifications to the exterior home without the written permission of the board. And the guy goes, go pound salt. I can do whatever I want with my house. I own this house, right? And the manager gets back to the board president and goes, hey, the guy told me to pound sand. And the board president goes, wow, maybe we should reach out to the lawyer. And he goes, yeah, you know what? I don't want to spend attorney fees. Let's just see what happens, blah, blah, blah. There's a meeting sometime in November. We'll discuss it at the November board meeting. Okay, and then the manager says, that's fine. Let's see what the whole board thinks. So between October 4th and the November board meeting, the addition is completed, right? And it looks beautiful. It's a beautiful addition. And it costs the homeowner $100,000 to put the addition on. And at the November board meeting, the rest of the board is informed of this. And they go, we are outraged. We want no modifications to the exterior of the home. You go call Fran McGovern and tell them, I want a complaint and order to show cause directing them to tear down that addition. The judge will laugh at you, right? The judge will laugh at you because the association knowingly allowed significant harm to occur to the homeowner, right? When the association should have acted immediately. You must act promptly. You must act promptly when the association is aware that the homeowner is doing something that is not permitted. Now, again, generally speaking, the courts will say there's not an estoppel issue unless the homeowner significantly compromise themselves. So, for example, if someone puts up a Ring doorbell in the wrong location and you say, hey, you got to relocate that Ring doorbell and fix this hole you put in the siding, that's one thing. If it's ripped down a 600 square foot addition, that's going to be a problem. A judge is not going to allow that if the association knew it. There's a well-known case in New Jersey that involves an association that had a provision that said no in-ground swimming pools shall be permitted in the association, period. And the homeowner went forward and put in an in-ground pool. And during this time, various representative associations walked by and noticed that the swimming pool was put in and they didn't deal with it. They didn't file a complaint. They didn't stop it. And then after the fact, the association went back and sued the homeowner saying, hey, you didn't get our permission. And they went to court and the judge said, you gotta be kidding me. You were aware that somebody was spending whatever, 10, 20, 30, 40, 50, $60,000 on an in-ground swimming pool and you did nothing about it. And now we have a completed in-ground swimming pool in this person's backyard and you're asking me to tell them to rip it out, right? Judges are going to laugh at you in those circumstances. So if you see someone making a significant modification, promptly contact legal and management and have it stopped, right? Generally speaking, estoppel does not apply in the association world, but if the homeowners are significantly compromised and the association was aware of it, courts are not going to make them change that modification. At least that's been my experience. So you got to be very cautious about that. You know, the homeowner will say, I relied on their inaction, right? I was building my swimming pool and the board president walked by every other day and waved to me as I was putting in my swimming pool, right? The homeowner is going to testify to that. And the judge is going to say, this is crazy. You should have acted. You can't just sit on your hands when there's significant modification going on and then expect me as a judge to have them lose $100,000. Okay, does all of that kind of make sense? I know that was kind of fast. I was rambling a little bit. There are a bunch of questions in the chat. Mike, you want to take the
Hey,
first one?
actually, let me just make a quick comment, kind of following up on what we just talked about. So another kind of corollary issue to what Fran just brought up is if you see somebody that installs or makes a modification on their property or the association's property and the common elements in front of their unit or something, and somebody else has that in the community and that restriction was never enforced, and now we go to enforce it for the first time on this person, judges oftentimes will not permit the association to enforce it against one individual when it's not enforced against others. We had a case fairly recently where an owner installed sort of a retaining wall in the front area, and the association never approved it. It was not permissible. So then we file a lawsuit. We go down the whole road to get it to have them remove the retaining wall. And it turns out that there were about 6 other ones in the community that were never enforced. And we found out through the course of discovery, it's a large community, and it became really problematic. And a judge would not enforce the restriction against one if it wasn't being enforced against everybody else. So just bear that in mind when we're seeking enforcement.
Yep.
All right.
All right.
So
So I'll jump in, or you want to jump in, Mike?
Sure. So, all right. The first one is, can you do a brief difference between resolution and an amendment? So, generally speaking, an amendment is a change to your governing documents. So, communities have your bylaws, which provides for corporate governance, and then you have your master deed or declaration of restrictive covenants, which provide for your property rights and restrictions. When you want to make a change to a phrase or a term or a sentence or a provision in there, the membership would have to approve it. We'd have to go through an amendment process. Versus a resolution is something passed by the board under the authority provided to the board in the bylaws. So generally speaking, boards have authority to pass rules and regulations, restrictions pertaining to a variety of things throughout the community and behavior and whatnot. If the board is simply going to pass a rule, you can do that without any membership approval. It's done at an open board meeting. And if it's a policy, we should record these policy resolutions in the county clerk's office to put everybody on notice. So that's kind of the difference.
Yep. Okay. I think I may have skipped Eric here. So Eric says, hey, if we haven't touched on it already, can you talk about solar panels and political signs? So Eric, we're not gonna have enough time to address them today, but we will put it on the list for future First Fridays with Fran, because solar panels and or political signs can both be topics of their own. So we will circle back on that. Go ahead, Mike.
Yeah, so Aldemano writes, the master deed has to be changed with the township for land use purposes of adding patios that were not initially approved. So yeah, sometimes there are situations where any approvals would require township involvement. And Al, I'm familiar with what you're talking about with your community, where now the township has to be involved on a large scale to permit any patio extension. So sometimes something like that would be required, and potentially a master deed amendment would be required as well.
Right. So Bill says, kind of similar to what Al said, most townships require a letter from the association for expansions. So in terms of patios, yes, and in some towns, it's even more than that, right? So we had a town where the town wanted every extension to come before, I believe it was the planning board, for each application, every single one. And what happened there, that just made it cost prohibitive, right? Because no homeowner wanted to go through the hundreds of homeowners. I want to do the same exact application, right? So that's engineering fees, that's application fees, that's attorney fees, etc. So what the association did there was they paid us to go in front of the planning board and have a, just like we said before, kind of standardized modification approved as to each home. So the township allowed the planning board to pass a resolution that said, in this community, if you want to expand, I think it was your deck, as long as you do it this way, you don't have to come before the planning board every single time. And the association wound up underwriting that standard application before. I think it was the planning board. It was. So yes, the township may require it. And there are times where a lot of times it's a lot more than a letter. There are so the other thing to keep in mind with townships is a lot of townships, if it doesn't require a planning board application or a permit application, they won't care, right? So they go to, some people don't realize how the associations work. They'll go to the township and they'll just say, hey, do I need to do anything else? And the township will be like, no, that doesn't require a permit. And they go out and do it. And they go back and hey, say, wait a second, I went to the construction official and the construction official said I could do it. So I did. And you go, yeah, that doesn't help you, dude. So be careful with that. Go ahead, Mike.
All right. Ella asks, what should a HOA do when a homeowner refuses to sign the hold harmless clause on a modification application they submit? So generally speaking, if somebody wants to make a modification to common property or property that they own, but the association is responsible to maintain, repair, or replace, we would require them prior to the board authorizing it to sign and complete a modification agreement that is, as Fran mentioned before, recorded in the county clerk's office against their unit. So when they sell their property, the purchaser knows that they are now responsible for the, fill in the blank, the deck extension, the patio extension, the satellite dish where they made a hole in the roof or whatever it may be. So my answer would be the association should require it prior to authorizing it.
Right. Otherwise, you don't have to give them the authority to do a modification. And then you follow up, Alba, with a comment that says the application is a deteriorating aspect of the outside of the house. HOA has asked them to fix. So that's not really truly a modification. That's just failure to maintain, repair, and replace their own property, which in itself is a violation. And I haven't looked at your documents in a while, but generally speaking, the association can put those people on notice. It says you have an obligation to maintain, repair, replace. If you don't maintain, repair, and replace on or before, say, October 15th, the association will undertake to maintain, repair, and replace it and charge back your account. Now, there are certain technical things that you have to do before that, but most association governing documents allow the association to do that if the homeowner fails to maintain, repair, and replace. The only other caveat to that is attorney fees, right? You wind up having to get us involved because more often than not, say they're not maintaining a physical aspect of the outside of the home, the association contractor goes in there to, I don't know, fix the front door or what have you. The homeowner runs out the front door in her underwear and goes, you can't come on my property. I hate you. I hate the association. The board are a bunch of fascists, right? Everyone's heard that, right? And obviously she doesn't know what fascists are, or he doesn't know what fascists are, but that's the reaction you get, right? And then the cops come, right? Because before she ran out in her underwear, or he ran out in his underwear, he called 911 and told the cops, there's someone trying to trespass on my property and violate my property rights. You've heard me say this before. The cops are, number one, first and foremost, peacekeepers, right? Peacekeepers, peace officers. So the cops are not going to go and lock up the lady or lock up the guy and say, you have to let them fix the siding. No, the cop's going to get me on the phone and say, hey, Fran, there's a problem out here. We're sending your contractors home until you get a court order that a judge says, I have to allow the contractor to come on and do the siding. So that's the problem. You can do what I said in terms of the association fixing and charging back unless they try and stop you. If they try and stop you, don't even bother with the police officers or calling the police and saying, oh, the master deed says I can fix the siding. The police officer is going to say, listen, I don't read master deeds. I'm here to keep the peace, go home, right? So just reach out, have the contractors go off the site, reach out to us or whoever your lawyer is and say, hey, we have a problem. We need to go forward. We need to make this repair. And the person's not allowing us. What should we do? And you're going to wind up trying to get a judge to issue an order. And in my experiences, the judge, will issue an order, right? The judge says, what are you talking about, right? You're allowing this place to fall down around you, and the association has the right under the governing documents to maintain, repair, and replace if you fail to. Okay, does that make sense? Go ahead, Mike.
I know we're a little over 5 here, so we're going to move along real quick. So
yep.
We have a next Question is, we have a provision in our bylaws that failure to enforce a rule does not mean that the HOA is restricted from enforcing it in the future. Is that rule not going to stand up in court? I think generally speaking, that rule is permissible and would be upheld in court. I think Fran was talking about more or less an outlier type situation where there's a massive project that the association sees, chooses to not address, and they could have stopped it. Correct, Fran?
Yep. Can the board have an illegal modification that was existing and no one is sure how it was allowed be removed at the time of sale of the home with escrow held until it is removed or collected? So that was Kevin. So the answer is yes, but it depends on the agreement you negotiate and the facts behind it. So we have a number of those situations where we send a violation letter out. Hey, we don't know what happened here, but you made an illegal modification. And they go, we don't care. We're keeping it. Leave us alone. And we said, well, that's unfortunate because now we're going to sue you. And they say, well, we don't want you to sue us and we're going to get our own attorney and we're going to spend tens of thousands of dollars. An option, as Kevin alluded to, is having an agreement that says upon transfer of title, the homeowner will remove the modification at his or her expense. So that is an option, Kevin, for sure. Go ahead, Mike.
The next comment here says, in the beginning of 2020, we signed on with ARC Tracker, a computer service that made a paper trail and specifications for any modifications. Previously, it was all done by hand, and people would give some of the paperwork to the president or management, and no one knew when it was all submitted. And I think that's excellent. That, however, really doesn't address the fact that the subsequent purchaser of the property may not be aware of modifications that were made. Certainly over time, sometimes management changes, law firms change, board members change, and you just don't want the paper trail to die. So to ensure that doesn't happen, if you record an architectural modification agreement against the unit's deed, the subsequent owner would be on notice.
Yep. So Barb says, what if a modification was done before transition and now we have a rule against the modification, standing soldier bricks along the driveway? I assume that means like the Belgian blocks are actually standing up. So the question there is generally you can't post, I guess what they would call ex post facto rules. You know, the rule is passed today, but now we're prohibiting it and you have to rip it out. There are some exceptions to that. The exceptions generally relate on things like life, health, safety. So if this was a life, health, safety issue that was created there, you may be able to have them modify it. But generally speaking, you're going to be stuck with it if it's just an aesthetic thing. Let's say, for example, if these pavers that were sticking up created a tripping hazard, walking down the sidewalk, you may have a shot. Otherwise, I think you're stuck with it for now. Again, this is all fact sensitive, but I think if the restriction wasn't made until later, you're going to be stuck with it. Go ahead, Mike.
All right, next one. We have had many homeowners, individual homes, fail to request modification approval, instead just doing it without approval. It's become common. We have since instituted a $100 fine. What else should be done? Yeah, this is like the age-old issue where the new board takes over and they're going to enforce everything and they realize that nothing's been enforced for years and it's like, oh my God, what do we do now? So generally speaking, if it's a rule that we want to enforce, I think you try your best to start enforcing it. If it's something that it's not going to be worthwhile to enforce, or maybe we just want to allow the changes that have been made, then change your rules to allow those changes so that you don't have an issue with them. And hopefully you can clear up what is permissible and what is not permissible, and then go after the not permissible items.
Right. Yep. And keep in mind, Gabe, the fine generally is not $100, right? So the fine is $100 per diem, right? So it's what would be called a continuing violation, right? So someone goes out and puts that addition on their home illegally, they thumb their nose at the board, we'll do whatever we want, screw you. And the violation letter goes out and it says, dear Mr. Jones, you made a modification without approval. You're subject to a fine of $100 per day. You have an offer of alternative dispute resolution if you'd like to participate in it, but the fine is going to accrue on a daily basis until the modification is removed or otherwise approved. So that fine would accrue at $100 a day until the addition is gone. I think, correct me if I'm wrong, I think it's $5,000 now, the cap
Yes.
on a fine accrual. So it would accrue at $100 a day up to the Hotel and Multiple Dwelling Act cap of $5,000, right? So people can thumb their nose at $100, but on a daily basis, not many people are going to thumb their nose at $5,000. There are people who would, But that doesn't mean even if they pay the $5,000, they get to keep the violating modification. The association can still sue the homeowner to have the illegal modification removed. Again, aside from the estoppel issue that we talked about before. And Terry Vigiano says, miss you, Fran, gotta fly. Have a great weekend. That's nice, Terry. I hope you had a good one. I'm sorry we missed you for the last 2 minutes. But thanks so much. I'm sorry we went over a little bit, but I think we covered a lot of ground today. And I hope everyone was happy with it. I hope you all have a happy Halloween. I won't see you before. So I hope you have a happy Halloween. I hope all the kids are happy out there and the adults too. And thanks again for attending. I always appreciate you very much. Thanks for attending.